Hey everybody, this one is called Do-It-Yourself Land Patents. How to bring forward your land patent. Um, so let's get going. Copies of these documents can be found in my private group at Yahoo called Administrating-Your-Public-Servants. I have videos that are videos of private information shares that show these and other court citations that are available for a donation. The donations to support this work are appreciated as last paragraphs for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966, because they can put their privileges and benefits up their rectal orifice. I prefer gold or silver coin. But as an extremely less desirable alternative, I can accept the IOUs, the commercial paper, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars. Anyways, we're all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? Well, they obviously have not. Matter of fact, there's people that can't even spell that are graduated from these schools nowadays. And all of these problems are really self-inflicted because of our own ignorance, really, if you think about it. Did you pay for your land with Federal Reserve notes or their equivalent? Well, that's a problem, okay, because that's not paying, okay? That's discharging a debt with limited liability. Can the bail priests in the so-called courts presume that you use Federal Reserve notes or their equivalent? Was the payment shown on the deed? Was it as a vertical S with a one vertical bar, or was it an S with two vertical bars? Okay, that's the original dollar sign was with the two. Did you have a mortgage? Only a U.S. citizen can access bankster debt. Can the bail priests in the so-called courts presume that you're a U.S. citizen? If any of those things happen, then there's some clouds. This is the Gold Reserve Act of 1934, located at 48 Stat 337. Section 15, as used in this act, the term United States means government of the United States, and the term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. And so that's Section 15. So again, Federal Reserve notes are meant for internal use of the government only. Title 12, United States Code, Section 411. Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through the Federal Reserve agents as hereinafter set forth, and for no other purpose are authorized. Okay, so they're not authorized. You're not authorized to be using them. Okay, you're supposed to be using gold or silver coin. This gives them the presumption, okay, that you're a bank or a U.S. citizen. Okay. The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks for all taxes, customs, and other public dues, and they shall be redeemed in lawful money on demand at the Treasury Department of the United States, in the city of Washington, District of Columbia, or at any Federal Reserve bank. There's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. Boy, these liars just lay awake at night dreaming this stuff up. So if you discharge the debt with limited liability, then you didn't pay it. A promissory note is a contract, a written promise to pay a certain sum of money in the future unconditionally. A promissory note differs from a mere acknowledgement of debt without a promise to pay, as when a debtor gives his creditor an IOU. That's what a Federal Reserve note is an IOU. Okay? There's no promise to pay on there. There's nothing on there that says anything about a promise to pay. It's commercial paper. All commercial paper falls into two categories. It's either a promissory note or an IOU. I don't care whether stocks, bonds, whatever. And a promissory note has to have a promise to pay. If there's no promise to pay, then it's not a promissory note. And now a little advertisement. Don't forget to subscribe to this channel. Don't forget to click on the bell next to the subscribe button so that you're notified when there's a new upload. And there's my front page of my channel, and there is the button. And the arrow is pointing at the bell, And what you do is you got to click on the bell. A little pop-up will come up and ask if you want to be notified. And the answer is yes. That's assuming you do want to be notified. This is an act making further provision for the sale of public lands, which was approved April 24th, 1820. Volume 3, 16th Congress, Session 1, under Section 2, and it's located at 3 Stat 566. And in Section 2, it says, and be it further enacted that credit shall not be allowed for the purchase money on the sale of any of the public lands which shall be sold. So they're selling lands, and they're saying you cannot use credit. And then there's a Senator King of New York in March of 1820, during the passage of the act for the sale of public lands, made these comments. It was calculated to plant in a new country a population of independent, unembarrassed freeholders, that it would place in every man the power to purchase a freehold, the price of which could be cleared in 3 years, that it would cut up speculation and monopoly, that it would prevent the accumulation of alarming debt, which experience proved never would and never could be paid. Well, no joke, Batman. And that's true today as well. But so the point is that the whole idea of a land patent is that it's unassailable. It cannot be touched. This is Wallace versus Harmstad, Supreme Court case, 1863. We are then to regard the Revolution and these acts of assembly as emancipating every acre of the soil of Pennsylvania from the grand characteristic of the feudal system, even as to the lands held by the proprietaries themselves. They held them as other citizens held under the Commonwealth, and that by a title purely allodial. All our lands are held mediately or immediately of the state by the titles purged of all the rubbish of the Dark Ages, excepting only the feudal names of things not any longer feudal. Under the Acts of Assembly I have alluded to, the state became the proprietor of all lands, but instead of giving them like a feudal lord to an enslaved tenantry, she has sold them for the best price she could get, and conferred on the purchaser the same absolute estate she held herself. And these have been reserved, and as everything else has been granted by contract. And so the point being is that we're back in the feudal system. And again, a feudal lord to an enslaved tenantry. Okay, why do you think they ask you when you want to title the land, do you want it tenants in common or joint tenants? Don't you get that stuff? Hello? If the American Revolution, after the American Revolution, lands in this state, Maryland, became allodial, subject to no tenure nor to any services incident thereto. And that's Henry Waltz, Barlow versus Security Trust and Savings Bank, 1925, quoting Matthews versus Ward, located at 10 Gill and Johnson, 1839. So the point being is that while we're back in feudal titles is what's happened, but you don't have to be. Okay, this is all coming from the Roman cult, and so you can take it back. This is McConnell versus Wilcox, 1837. From what source does the title to the land derive from a government spring? In arbitrary governments from the supreme head, be he the emperor, king, or potentate, by whatever name he is known. In a republic, from the law making or authorizing to be made the grant or sale. In the first case, the party looks alone to his letters patent. In the second, to the law and the evidence of the acts necessary to be done under the law. To a perfection of his grant, donation, or purchase, the law alone must be the fountain from whence the authority is drawn, and there can be no other source. McConnell versus Wilcox, Illinois, 1837. A land patent is the minument of title, such title being absolute in its nature, making the sovereigns absolute freeholders on their lands. Finally, the patent is the only evidence of legal fee simple title. And so again, they're calling the people sovereigns. Think about it. freeholders, sovereigns, absolute freeholders on their lands. Absolute title. This is 12 Stat 292, Chapter 45, August 5th, 1861. This is where the property taxes started. Okay, an act to provide increased revenue from imports to pay interest on the public debt and for other purposes, be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. So you have to understand, an act to increase revenue from imports. Okay, so really this is a DC statute. This is not for the United States. Congress can operate as a legislature for the District of Columbia, and Congress can operate as a legislature for the United States of America. In this act, they're talking about imports, okay? And so, and yet they're going out to Maryland or Texas, and they're taxing it. And so they're not operating as the legislature for the United States of America. They're operating as the legislature for the District of Columbia. Think about it. That's exactly what's going on here. And so the point being is that it's only U.S. citizens that it applies to. And that's, I mean, if you look in their statutes, if you look all over the place, it only applies to U.S. citizens. And a U.S. citizen is, I mean, if you watch my other videos, a U.S. citizen is assessed to K-Trust. It all ties back to the Roman cult. This is Section 8. And be it further enacted that a direct tax of $20 million be and hereby annually laid upon the United States, and the same shall be and is hereby apportioned to the states respectively in manner following. Okay, so see, this is wordsmithing big time, because if you understand the law, the states are Guam, American Samoa, and Puerto Rico. Because Texas isn't one of the states, okay? And so we're talking about, this is a statute for the District of Columbia and the territories. So, and the states are Guam, American Samoa, and Puerto Rico, Virgin Islands, you know, that kind of stuff. And be it further enacted that for the purpose of assessing the above tax and collecting the same, this is Section 9, the President of the United States being is hereby authorized to divide respectively the states and territories, the United States and the District of Columbia into convenient collection districts, and to nominate and by and with advice of the Senate to appoint an assessor and a collector for each district, who shall be freeholders and resident within the same. And so again, if you, there's court cases that say that the District of Columbia boundaries expand as needed for U.S. citizens. And so again, so any state in America can be part of the District of Columbia, okay, and its territories. But it's really the states, and when they say the states and territories, well, it's like saying the territories and territories. That's exactly what they're doing. Because again, it's imports, okay? They're talking about imports, an act to increase imports, revenue from imports. And so they're they're turning the states, the real states, into territories. And so they're talking about states that are really territories, and the territories. But again, it's because of the U.S. citizens, okay? Because U.S. citizens, no matter where they're at, the District of Columbia boundaries expand as required for a U.S. citizen. I show that in all my other videos. Not all of them, a bunch of them, most of them, actually. This is Section 10, and be it further enacted that before any such collector shall enter upon the duties of his office, he shall execute a bond for such amount as shall be prescribed by the Secretary of the Treasury, with sureties to be approved as sufficient by the Solicitor of the Treasury, containing the condition that said collector shall justly and faithfully account to the United States and pay over, you know, whatever. The point being is that they have to execute a bond. They're all bonded. Section 13, be it further enacted that the said direct tax laid by this act shall be assessed and laid on the value of all lands and lots of ground and their improvements and dwelling houses. See, this is all property taxes. Which several articles subject to taxation shall be enumerated and valued by the respective assessors at the rate each of them is worth in money on the first day of April, 1862. So this is all talking, this is where direct taxes on land started. Section 14, be it further enacted that the respective assistant assessor shall immediately after being required as aforesaid by the assessors, proceed through every part of their respective districts, and shall require all persons, okay, that's U.S. citizens, owning, possessing, or having the care or management of any lands, lots of ground, buildings, or dwelling houses, lying and being within the collection district where they reside, and liable to a direct tax as aforesaid, to deliver written lists of the same, which lists shall be made in such manner and may be directed by the assessor. Okay, so under the authority of the respective states. So the point being is liable, and they have to be liable to the tax. Okay, so it's got to be persons, shall require all persons. Okay, so that's U.S. citizens. That's, I mean, look in Article 14th Amendment, Article 1. All persons born and naturalized in the United States are citizens of the United States. This is section 29. Be it further enacted that soon after the said board assessors shall have completed their adjustment and equalization. So this is talking about equalization, okay? And you see that all over the place where there's a board of equalization, okay? And this is where they're talking about that. This is where it all started. Section 43, and be it further enacted that each and every collector or his deputy who shall exercise or be guilty of any extortion or oppression under color of this act. So this is basically the predecessor to Title 18 United States Code, Section 241 and 242. When it was codified, that's what it became. That's where this went to United States Code under Section 241 and 242. And be it further enacted, there shall be allowed to the collectors appointed under this act in full compensation for their services and that of their deputies in carrying this act into effect, a commission. So they get a royalty of whatever they collect. So they're going to go and they're going to try and collect it from anybody and everybody. And if you just pay it over, then it's a contract. You just consented. It's an agreement. And where there's no law that says you dare, unless of course you're a U.S. citizen. And actually, I can show that nobody's a U.S. citizen. So you just volunteered in. It's exactly what it is. Well, and also these guys are a bunch of crooks, okay? They perjure their oath, but nobody's holding them accountable, okay? You know, if you expect them to be accountable, you got to hold them accountable. And this is the Homestead Act, an act to secure homesteads to actual settlers in the public domain, which is approved May 20th, 1862. Okay, this is again another charade that Congress did. Okay, that be it further enacted that the person, okay, so that's a U.S. citizen, for the benefit of this act shall, upon application to the register of the land which he or she is about to make entry, make affidavit before the said register that he or she is the head of the family, 21 years, and the purchaser. So you have to automatically, if you make the affidavit, you're a person. Okay, and so and they're converting a right into a privilege. Okay, because if you have the land patent, they cannot touch it for any reason. Land patents are untouchable. This is an act to secure homesteads to actual settlers in the public domain. This is up here. That was section 2. This is section 4, located at 12 Stat 393. That was at 12 Stat 392. So this is the next page, section 4. Be it further enacted that no lands acquired under such provisions of this act shall in any event become liable to the satisfaction of any debt or debts contracted prior to the issuing of the patent therefore. So the point being is that they're converting a right into a privilege. Okay, that's obviously changed. Every state's going to have different statutes now. Matter of fact, Congress quit legislating on that stuff. It's all, they turn it over to the states. And so, again, that's converting a right into a privilege. If you have the land patent, they cannot touch it. They cannot, you will not be able to get a mortgage on it. You will not be able to get title insurance. If you bring forward the land patent and do it properly, I mean, they won't be able to touch it. It'll be untouchable. A person is only a fictitious entity. An act prescribing the form of enacting and resolving clauses of acts and resolutions of Congress and the rules of construction, which was approved February 25th, 1871. And it's located at 16 Stat 431. Be it further enacted, in all acts hereinafter passed, the word person may extend and be applied to bodies politic and corporate. So it's a fictitious entity. That's a Sestakate Trust. An act concerning the construction of statutes. This is Arizona statutes, okay, which was approved January 2nd, 1852. See, Arizona was originally part of New Mexico, so this is actually a New Mexico act. Be it enacted by the Legislative Assembly of the Territory of New Mexico that the construction of the statutes in this territory, the following rules, shall be observed. The word person may be extended to bodies politic and corporate. Okay, so it's fictitious entities. This is an act to provide temporary government for the state of Arizona. And so this is when Arizona was split off from New Mexico, together with all legislative enactments of the territory of New Mexico not inconsistent with the provisions of this act are hereby extended to and continued in force in the said territory of New Mexico. That's located at 12 Stat 665. So that's the federal act to provide a temporary government for the territory of New Mexico. This is 26 U.S.C. 7701. When used in this title, were not otherwise distinctly expressed or manifestly incompatible with the intent thereof. See, these liars like to put in all this stuff that makes people confused, but really, all you have to know is when used in this title. The term person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. So include is limiting. And so when they say mean and include, they're just trying to confuse you because really it's mean and mean. And under the maxim of law, justum generis, individual is a fictitious entity because all the rest of them are fictitious entities. So an individual is a sesticate trust, and they actually talk about a trust. Okay, but an individual is just a sesticate trust. And now another little diversion, announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 a month because it avoids the advertising only. You know, when I first set this up or was starting to set it up, I was wanting to have some exclusive content on there. And I do actually have an Arlington private information share that's on there exclusively. But I couldn't think of anything on there because my agenda, it really is to expose these New World Order Satanists, the fraud and deception that they're engaging in, to expose it for all our benefit. And because of that fact, I couldn't think of anything that I wanted to put on there exclusively. And so there's, you know, at this point, I can't guarantee there'll be anything exclusive except that Arlington private information share. But but you won't get any advertising. I'll tell you that. And so $1.99 a month will get you to watch the videos. I'm putting out actually 5 videos a week these days. And so you'll for $1.99 a month, you'll get 5 videos a week. And if you click on the bell, you'll get notified when they get uploaded. And so yeah, that's about as good as it gets. Sorry, but that's as good as I can do. Anyways, some people had trouble finding my YouTube channel, and so I put a link at the bottom of the page. And this is my YouTube channel, The Matrix, Sovereignty International. And at the top is a link again. So if you have trouble finding it, you can do that. Once I get my subscriber base up, I can actually get a customized URL. But until then, that's all I get. Anyways, and I had people send me a $1.99 donation, and I was thinking that maybe it was for subscribing them to the channel, and I sent them an email. They haven't responded. I offered to refund it if that was the case, because I cannot subscribe anybody. You have to click on the start free trial, and imagine YouTube is probably going to want to set up some payment arrangements or something, because I cannot. I have no control over that at all. The only thing I can see some of my subscribers, the ones that allow me to see them. And so based on that, I might be able to remove some of them if, you know, they wanted me to remove them. But that's about as good as it gets. I mean, I just have no control over that at all. So if you want to, you know, make a donation, I certainly appreciate donations. Don't get me wrong. And by subscribing to my channel, you're welcome to. I'd appreciate it. But don't send me money thinking that I'm gonna be able to subscribe you to the channel, because I cannot. You're gonna have to go and click the start free trial button and do it yourself. Sorry. Anyways, back to the topic at hand. Remember we were talking about, let's go back. Include. Okay, and include and justum generis, because person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. Well, include is defined to comprise within, to hold, to contain. It's limiting. Okay, that's Montello Salt versus Utah Supreme Court case. Include is to confine within, to hold, to contain, as the shell of a nut includes the kernel. A pearl is included in a shell. And so the point being, and there's all sorts of law dictionaries, Black 6, English, Noah Webster's Dictionary of the English Language, court cases. I mean, it's pretty well settled that include is limiting. Adjustum generis, remember I talked about that, a canon in construction that when a general word or phrase follows a list of specifics, the general word or phrase will be interpreted as to include only items of the same type as those listed. For example, in the phrase horses, cattle, sheep, pigs, goats, or any other farm animal, the general language or any other farm animal, despite its seeming breadth, would probably be held to include only four-legged hoofed mammals typical found on farms and thus would exclude chickens. And that's Black's 8th. And this is the international law rule. All state statutes are actually federal statutes. Remember, we talked about that a little bit at the beginning. This is taken from a book called Jurisdictions Over Federal Areas Within the States, a report of the Interdepartmental Committee for the Study of Jurisdiction Over Federal Areas Within the States, Part 2. This document by itself is about 450 pages. The first one, the Part 1, is about 650 pages. And it's easily, you do a search at Google and you'll pull it up right away, get a PDF. Anyways, a text of the law of legislative jurisdiction submitted to the Attorney General and transmitted to the President June 1957. And this is basically taken from pages 158 to 165. So the international law rule adopted for areas under federal legislative jurisdiction federalizes state civil law, including common law. The rule serves to federalize not only the statutory, but the common law of a state. And then on page 165, it goes on, state and federal venue discuss the civil laws effective in an area of exclusive federal jurisdiction are federal law. Well, if you're a U.S. citizen, we're going to go through that next. If you're a U.S. citizen, then it's exclusive federal jurisdiction, notwithstanding their derivation from state laws. And a cause arising under such laws may be brought in or removed to a federal court. And the interesting thing is I filed a lawsuit in Arizona over property taxes and the Attorney General, because I named the Attorney General in it. The Attorney General removed it into federal court. And this is National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, U.S. Supreme Court, 1948. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power, that's an Article 1 military dictatorship, folks, nationally covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So, I mean, we were talking about that earlier. And this has been codified. If any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title to jurisdiction of the courts or enforcement of summons. And now another little diversion, an advertisement, cubeyard.com. For great custom websites, domain names, and hostings, go to cubeyard.com. Use coupon code CY172 for 20% off your first order. Cubeyard.com, your source for websites, domain names, and hosting. Back to the topic at hand. And so we'll have a little intermediate summary here. Originally, Congress intended that land could not be encumbered in any way. Property taxes were originated by an act of Congress in 1861 for U.S. citizens. The Homestead Act is a privilege for U.S. citizens. State statutes are actually U.S. statutes. And if you used, or the bail priests in the so-called courts can presume that you used, Federal Reserve notes to pay for land, then it's not paid for. Federal Reserve banknotes and other notes constituting a part of the common currency of the country are recognized as good tender for money unless specifically objected to. You can object to them. That's true. You can say, oh, I can't accept those. I bet you that day's not too far away. Dollar, the legal currency of the United States, the unit of money consisting of 100 cents, the aggregate of specific coins which add up to $1. In the absence of qualifying words, it cannot mean promissory notes, bonds, or other evidences of debt. Okay, so dollar does not mean Federal Reserve notes. They put that on there. That's a fraud. Okay, that's the Federal Reserve, the banksters. Okay, they're thieves. Banknotes constitute a large and convenient part of the currency of our country and by common consent serve to a great extent all the purposes of coin. In themselves, they are not money, for they are not a legal tender, and yet they are a good tender. Well, and actually subsequent to this is in 1923, so they went and passed a statute, because that's all they do, pass a statute saying this note is legal tender. Anyways, so in themselves, they are not money, for they are not legal tender, and yet they are good tender unless specifically objected to as being notes merely and not money. You can still object to them too, even though they are legal tender. They subserve the purposes of money in the ordinary business of life by the mutual consent, express or implied, of the parties to a contract, and not by the binding force of any common usage, for the party to whom they may be tendered has an undoubted right to refuse accepting them as money. And that's true. Bouvier's Law Dictionary, 1856 edition, banknotes, contract. A banknote resembles a common promissory note issued by a bank or corporation authorized to act as a bank, and it is in fact a promissory note, but such notes are not for many purposes to be considered as mere securities for money, but are treated as money in the ordinary course of and transactions of business by the general consent of mankind. It's all by consent. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. Okay, so that says volumes. Okay, forced loans, legal tender notes, which Federal Reserve notes are legal tender, are a forced loan then, aren't they? Because it says the forced loans of 1862, they're specifically talking about U.S. Treasury notes in this case. But it doesn't matter, because if it's legal tender, it's a forced loan. And they're part of the debt. Okay, because again, it's a forced loan. Okay, that's exactly what it is. And that's Juilliard versus Greenman, U.S. Supreme Court. So what's the solution? Well, the first thing you do is start objecting. Okay, quit taking the things. At common law, only gold or silver were legal tender. And that's actually an 1820 court case, McLaren versus Nesbitt, but they're citing Book 2 on Coke's Institutes on the Laws of England, which goes back to the 1500s. So again, at common law, only gold and silver are a legal tender. So what's solution 2? If you want common law, then you absolutely must have honest measures. That's why when you pay these filing fees, that's why I'm so adamant about refusing to pay this extortion that these bail priests are demanding, because it's not honest money. So they can just do whatever they feel like doing. I mean, because they know it's not honest money. They know nothing's paid for. They're nothing but a bunch of thieves. Don't get me going. Anyways, back to the topic about land. Don't get me going about bail priests. If you want lawful land, then you must defeat these bail priests' presumptions. Everything's under martial law. If you want to be a state citizen instead of a U.S. citizen, then you have to quit doing things that U.S. citizens do and start doing things that state citizens do. If you want to have all the rights and privileges of the land patent, then you need to bring it forward. Real property. That would consist of land and all the rights and profits arising from and annexed to the land of a permanent immovable nature. In order to make one's interest in land real estate, it must be an interest not less than for the party's life, because a term of years, even for 1,000 years, perpetually renewable, is a mere personal estate. Okay, so right here they're differentiating between real property and real estate, first of all. Okay, and everything they call nowadays is real estate. Okay, so if you think about it, a real estate is like your father's estate. Okay, you have an interest in your father's estate, but you don't own it. And the same thing with real estate. In order to make one's interest in land real estate, it must be an interest not less than for the party's life. Okay, so you have an estate. That's what you have. If you have real estate, you don't really own it. Now, you can have real property, but in order to do that, you got to bring forward the land patent. Then you'll have real property. Real property is land and everything that's attached to the land. Real estate is real property that you have an interest in, but you don't own it. Estate is the operative word. An estate is something you have an interest in, but you don't own, like your father's estate. Title, estates. A title is defined by Lord Coke to be the means whereby the owner of lands hath just possession of his property. And that's Coke's Littleton, page 345. This is the definition of title to lands only, okay? And so this is actually taken from Bouvier's Law Dictionary, 1856 edition. And there's a bunch of, there's 3, 5, there's like, let's see here. There's, oh, no. Oh, yeah, there we go. 7, 9. There's a bunch of them we're going to talk about here. But so anyways, so paragraph 3 talks about a title is either good, marketable, doubtful, or bad. Okay, so there's basically 4 kinds of title: good, marketable, doubtful, or bad. And a marketable title is one which a court of equity considers to be so clear that it will enforce its acceptance by a purchaser. Okay, and so because you hear about marketable title all the time nowadays. And the doctrine of marketable title is purely equitable. Okay, that's these courts of equity. And of modern origin at law, okay, now we're talking common law, every title not bad is marketable. So if it's not a bad title, it's marketable. Actually, that's under equity. That's not at law. Here's the common law, number 9. At common law, doubtful titles are unknown, where there every title must be either good or bad. Okay, and so there's no, at common law, there's no marketable title. It's either good title or bad title. Authorities hold that to render a title marketable is not only necessary, that it shall be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion. And so the point being is that, you know, nowadays when you get mortgages and stuff like that, they always talking about marketable title. Okay, they always, nowadays, that's all they talk about is marketable title. So you have to understand that. And this is back to that titles estates definition out of Bouvier's Law Dictionary, number 10. A bad title is one which conveys no property to the purchaser of an estate. Right. And title to real estate is acquired by 2 methods, namely by descent and by purchase. Now, I know people that have land patents on their land. They've never been on property tax rolls. They've never even had anybody looking them up for property taxes. And the way they pass it on is through their family. Okay, so you know, the son, the dad will basically say, why don't you take that 10 acres over there, and he gets him a quit claim deed, and so then he goes and lives on it. And think about it, after 7 years you got squatters rights, so you're on it. And so no matter if you got a piece of paper, and you never record that stuff, because it's only persons that are required to record it. And so that's how they do it, by descent. But you can also purchase it, but you have to do it in the right way if you want to make sure that you have all the rights and privileges of the land patent. These deeds include the ones as follows: warranty deed, quitclaim deed, sheriff's deed, trustee's deed, judicial deed, tax deed, will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. Okay, so color of title. So what's title? These are all color of title. Okay, so something that looks like title, acts like title, but it's really not title. The only real title is a land patent. And actually, even a land patent is colorable. Anyways, this is taken from G. Thompson, Title to Real Property, Preparation and Examination of Abstracts, Chapter 3, Section 73, page 93, in 1919. Color means an appearance, a semblance, or a simulacrum as distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, or a pretext. And that's Black's 5th. Color means, oops, what did I do? Go back? Oh, I did. Color means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. It's a fraud. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state is action taken under color of law. When we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea, at least, that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. And that's St. Louis versus Gorman, 29, Missouri, 593, 1860. So again, title, color of title. Where the complainant seems to have relied upon the tax deed in conveying to him the fee, and to sustain such a bill, it was incumbent upon of him to show that all the requirements of the law had been complied with. So this is an interesting case because you got to kind of read between the lines. This is Hulls versus Bunton, 47 Illinois, 396, 1865. And so if you think about it, you read this, okay, see, this guy bought some land with a tax deed, okay, and a tax deed, usually they're like a quitclaim deed. They're just about worthless. And and so what happened was he bought some land with a tax deed, and the other guy knew the law, and so he didn't buy anything. Okay, because look at what they're saying. They're saying to sustain such a bill, it was incumbent upon him to show that all the requirements of the law had been complied with. In other words, buyer beware. The buyer has to show that he's got something. And if the other guy knew the law, what he bought was nothing. And in this case, that's what he's saying. That's what the court's saying right here. And so again, I would never buy a tax deed. These tax thieves, they're nothing but thieves. They're preying on people who happen to be ignorant, and they're selling people's property that they have no right to sell. They're perjuring their oath. I mean, don't get me going about these thieves. And so, yeah, absolutely. Don't get me going. I never buy something from a tax sale. I don't even like buying foreclosures, quite frankly, because the bankster thieves are thieves. And, um, anyways. Land titles come in various forms: general warranty deed, special warranty deed, sheriff's deed, judicial deed, quitclaim deed, and a land patent. A general warranty deed is a deed where the seller warrants the title to be free and clear of all liens and encumbrances. A general warranty deed is generally what's received in order to get a mortgage before the bank will authorize the mortgage, and it's considered marketable title. A special warranty deed is a deed where the seller will warrant the land free of all liens and encumbrances with some reservations. Okay, that's usually when it's a foreclosure or tax sale. Usually it's a foreclosure. The tax sales are almost always quitclaim deeds. A special warranty deed is considered marketable title. A sheriff's deed is when a sheriff sells a piece of property, and could be a foreclosure or tax sale or something like that. A sheriff's deed is considered marketable title. A judicial deed is when a judge orders the real property sold. A judicial deed is considered marketable title. A quitclaim deed essentially says that the seller transfers his interest in a piece of property. Property sold because of a tax sale can be transferred by a quitclaim deed. A quitclaim deed can transfer title as effectively as a general warranty deed, and a quitclaim deed may transfer nothing. I don't know if you've ever heard of the Brooklyn Bridge being sold, but it has been sold on numerous occasions, and usually it's some, con man, and he always gives a quitclaim deed. Okay, so I sell my interest in this bridge. I may not have an interest, but what interest I have, I sell. That's what a quitclaim deed. A quitclaim deed is a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises. A patent to land issued by the United States under authority law is the highest evidence of title, something upon which the holder can rely for peace and security in its possession. It is conclusive evidence of title against the United States and all the world. And this is book 2, the American Law of Mining, and at 1.29 at 357, and is citing Nichols versus Rice AV, 610 Federal Supplements, 1254. Nothing but a patent passes a perfect and consummate title. A patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent. And that's Land Patents, Opinions of the United States Attorney General's Office, September 1869. So, um, so mortgages even theoretically should not prevail against a patent. If you bring forward your land patent, then that hurts them in a major way. And knowing what I know now, although I don't even deal with the bankster thieves, but knowing what I've been doing about the seeing in the Uniform Commercial Code lately, I would definitely, I'd bring forward the land patent, and I think I could win in court, quite frankly, because again, all you have to do is challenge again, under the Uniform Commercial Code, it's all come from the UN. So you just challenge the deed and make them prove that they have something, or not the deed, the mortgage signature on the note. Where's the signature? I don't remember signing any notes. A patent is the highest evidence of title and is conclusive against the government and all claiming under junior patents or titles until it is set aside or annulled by some judicial tribunal. And that's Stone versus United States, 1865. Issuance of government patent granting title to land is the most accredited type of conveyance known to our law. A patent is intended to quiet title to and secure the enjoyment of the land for the patentees and their successors. Thus, as a quitclaim deed, a land patent conveys whatever interest the government has in the soil and the land. And this actually, if you think about it, a land patent's a quitclaim deed. Think about that. We're going to talk about that in a minute. As we have noted, in connection with a patent by the United States, the patent's effect is the same as though the United States had executed a quitclaim deed. A patent operates as a deed of the government. As a deed, it operates as that of a quitclaim. It passes only the title the government has on the date of the patent. So a patent to the United States as a deed, its operation is that of a quitclaim, or rather of a conveyance of such interest as the United States possessed in the land. And so, did they really possess interest is the question, isn't it? A land patent is the highest and best title, but at the same time, it's a quitclaim deed, which is a color of law. If a land patent is colorable title, then what would be the true allodial title? Think about it. There is nothing here requiring a deed to establish a color of title. Under the former decisions of this court, color of title may exist without a deed. That comes with squatters' rights. Okay, really, you just live on the land. That's why they went in the old days, the people, in order to do the homesteading, they had to live on the land for 7 years, and then the government would give them a quitclaim deed, or not a quitclaim deed, a land patent. But they had to live on the land first for 7 years. Okay, and the reason is who owned the land? Well, before the government, if you look at the Treaty of 1763, not the treaty, the Royal Proclamation of 1763 that was done by the Crown, everything west of Quebec, okay, was Indian territory. Everything west of the colonies at the time was Indian territory. And so it was all Indian territory. So the Indians, the First Nations, are the ones that really own the land. If you go and live on it for 7 years, then the government gives you a patent. But you have to live on it for 7 years. You have to make an affidavit or something showing you lived on it for 7 years. And that's really where the color of title exists without a deed. The courts have ruled that the government has to settle the land claims of the original people. They're essentially saying that the government stole their land. And that's true, especially in Canada. Contact information. My blog, this is a little interlude. This ain't over by a long shot. My blog is SovereigntyInternational.wordpress.com. My website is SovereigntyInternational.fyi. My email is engineerwin@yahoo. My YouTube profiles are Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My Facebook private group, Sovereignty International, is being deleted, but it takes time to ban 17,000 people off your group. And I'm not going to let Facebook profit off of my hard work. My Yahoo private group is Administrating Your Public Servants, and my Google private group is Administrating Your Public Servants. And this is a Crown patent from Canada. And what these Satanists like to do is they transfer it to a company. It's probably a Crown Corporation in this case. And then they transfer it from the Crown Corporation to you. So then you always get a color of title. Nobody really gets a land patent except the Crown Corporation. Right? They stole it from the First Nations. Notice it's in square box too. Okay, so there's technically, that's the law of four cornering. There's nothing on that page. This is a U.S. patent. This is one of the railroad patents when the railroads went in, they were granted 10 miles of land on each side of the railroad to basically finance the railroad. So the government didn't give them money, but they did give them huge tracts of land. So they got the land, and then they basically sold the land and used that money to pay for the railroad. Anyways, this is patent number 43, Santa Fe Pacific Railroad Company, primary limits, Phoenix Land District. This is actually some of my land that happens to be in this patent. That's the reason I got a hold of it. And it says here, well, let's read it. To all whom these presents shall come, greeting. Whereas by act of Congress approved July 27th, 1866, 14 Stat 292, entitled an act granting lands to aid in the construction of railroad and telegraph line from the states of Missouri and Arkansas to the Pacific coast. There was granted to the Atlantic and Pacific Railroad Company, its successors, and assigns for the purpose of aiding in the construction of said railroad and telegraph lines to the Pacific coast, every alternate section of public land, not mineral, designated by odd numbers, to the amount of 20 alternate sections per mile on each side of said railroad line, as said company may adopt through the territories of the United States, and 10 alternate sections of land per mile on each said side of said railroad whenever it passes through any state, and whenever on the line thereof the United States have full title, not reserved, sold, granted, otherwise appropriated, and free from preemption or other claims or rights at the time the line of said railroad is designated by a plat thereof, filed in the office of the Commissioner of the General Land Office, and said act provided further that the word mineral, when it occurs in this act, shall not be held to include iron or coal. And whereas official statements bearing dates December 17th, 1880, April 19th, 1881, January 7th, and December 16th, 1882, and November 3rd, 1883, have been filed in the General Land Office, showing that the commissioners appointed by the President under the provisions of the fourth section of the said Act of Congress, approved July 27th, 1866, have reported to him that the said line of said railroad and telegraph from a point in Township 8 North, Range 2 East, Territory of New Mexico, and ending at a point on the west bank of the Colorado River in the state of California, has been constructed and fully completed and equipped in the manner prescribed by the Act of Congress. And whereas certain tracts of land have been listed by the duly authorized land agent of the said Atlantic and Pacific Railroad Company as shown in this original list, approved by the local officers and now on file of General Land Office. And whereas it is shown by evidence filed in the office of the Secretary of the Interior of the Santa Fe Pacific Railroad Company under the purchase at foreclosure sale of the property and rights of the Atlantic and Pacific Railroad Company, and by compliance with the provisions of the Act of Congress approved March 3rd, 1897, 29 Stat 322, became the lawful successor in interest of the Atlantic and Pacific Railroad Company. So I guess Atlantic and Pacific Railroad Company went bankrupt, and so then the Santa Fe Pacific Railroad Company took it. And whereas the said tracts of land lying coterminous with the constructed line of the road within 40 miles thereof and are particularly described as follows. And so you basically have sections, townships, and ranges. Now, I'm not going to go through all those, but you can see there's a bunch of them. Matter of fact, there's 4 pages. Containing an aggregate 260,334 and 53/100 acres for all of that. Okay, so you're talking 260,000 acres. So one section is 640 acres. So there's a bunch of sections. Anyways, know ye that the United States of America, in considering of the premises and pursuant to the acts of Congress, has given and granted by these presents, does give and grant unto the said Santa Fe Pacific Railroad Company, successor in interest to the Atlantic and Pacific Railroad Company, and to its successors, and assigns the tracts of land listed as aforesaid and described in the foregoing, to have and to hold the said tracts with the appurtenances thereof unto the said Santa Fe Pacific Railroad Company, successor as aforesaid, and its successors and assigns forever. Okay, it doesn't say anything about mineral rights. Okay, actually, it does talk about it earlier, but it says it doesn't include iron or coal, so other mineral rights that the government reserves. Okay, but it doesn't reserve anything other than that. Okay, and that's all it says. Okay, it doesn't say anything about property taxes, doesn't say anything about easements, doesn't say anything about anything. Okay. In testimony whereof, Woodrow Wilson, President of the United States of America, have caused these letters to be made patent and the seal of the General Land Office to be hereunto and fixed, given under my hand at the city of Washington, the 2nd day of December, in the year of our Lord 1915, in the independence of the United States 140th year, by the President Woodrow Wilson. And then, it's got the recorder of the General Land Office and the secretary. And that's it. Land patents are really simple. And so recent land patents are inside a box. That's in the Crown patents. They know they have no authority. It says the land is granted to John Smith, his heirs, and or signs forever. All the Crown patents I've seen reserve something like mineral rights, trees, water rights, etc. All land patents say nothing about property taxes, say nothing about easements, say nothing about eminent domain or zoning rules or regulations. Sometimes they reserve mineral rights. Other than mineral rights, there are no reservations. A usufruct is the right of enjoying a thing, the property of which is vested in another, and to draw from the same all profit, utility, and advantage which may produce, provided it be without altering the substance of the thing. That's Bouvier's Law Dictionary, 1856 edition, page 1119. A usufruct is a type of a trust. When you pay for land with a banknote, which is commercial paper, it's not paid for. Therefore, a usufruct is created. Eminent domain, that's why the government has eminent domain. If you think about it, the government sold the land. By paying for the land with their commercial paper, you essentially give it back. Have you ever seen a road that goes along a straight line, and then when it comes to some guy's land, it turns and goes around the outside of the land, along the border, the property line, to where it's going straight again? That's because all those landowners really didn't own the land except the guy whose land they went around. That's true. I've seen it happen on more than one occasion. Spanish land grants in Arizona. I know people in Arizona who've had land in their family for generations and they do not pay property taxes, never have. And I've heard of people in Canada who, when they acquire about their land, the response from land title is that they don't have jurisdiction over the matter. Federal Reserve notes or Bank of Canada notes or Bank of England notes or IOUs is found in the Bankster Thieves 1, 2, and 3 videos. And then there's no such thing as a bank loan video. There's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. These whores, these bail priests, lay awake at night with this stuff. Evidence of your usufruct, they call it real estate. Okay, you don't really own it. You pay a yearly rent, which is property taxes. They can take it from you, eminent domain. And if they take it away from you, then you do not own it. Okay, if you don't pay the property taxes, they can take it from you. Your land has easements. Your land is subject to zoning rules and regulations. Then you don't own it. You have an estate. If you pay for your land with an IOU, which is legal tender, it creates a trust, a usufruct. The way you defeat the trust is you have to pay for the land with gold or silver coin, and you have to say it in the deed. How can you have true allodial title to land? What you do is you bring forward all the rights and privileges of the original land patent, pay for your land with gold or silver coin. At common law, all numbers are spelled out. In other words, it is 5, not the number 5. The number 5 is an Arabic numeral and in the matrix. Legal description should be in metes and bounds. You can say also known as, lot 1 of this Rancho subdivision, to eliminate any confusion. But a patent from the original people would trump any other patent, but most of them are afraid of it, quite frankly. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. Okay, this is the Roman cult we're talking about here. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiat to the use of the religious houses, thus distinguishing between the possession and the use, and the receiving the actual profits, while the season of the lands remained in the nominal fiat. who was held by the courts of equity, then under the direction of the clergy, that's the Roman cult, to be bound in conscience to account to assess decay use for the rents and emoluments of the estate, that's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Well, in 1835, it was the foundation of it's still the foundation of modern conveyancing. Because almost everything is done these days with commercial paper, the courts presume that commercial paper was used. You can defeat their presumption by putting on the land transfer document the type of payment that was received, gold or silver coin. And now another little diversion. Check out my other videos, Bankster Thieves 1, 2, and 3, Churchianity series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do It Yourself, How Not to Volunteer for the Selective Service, Martial Laws here, Do It Yourself, No Income Tax, Do It Yourself, No Sales Tax, Do It Yourself, Traffic Stop 1 and 2, Do It Yourself, Free Mail 1 and 2. And back to the topic at hand. So what you do is you make up a bill of exchange. Okay, I usually call it a grant deed and bill of exchange. Upon receipt of 20 each 1 troy ounce pieces of pure silver each, I do hereby grant to an exchange to John Henry, House of Smith, this land, and you put in the legal description and together with all the rights and privileges, the original land patent number 1234556, a true copy of which is attached here too, all of which is incorporated herein by reference in its entirety. When you get the true allodial title, you do not tell them you purchased your land. If you purchased or bought your land, it's a commercial transaction. You tell them that you converted some silver or gold to land. Conversion is common law. I've seen court cases that have talked about it that way. Some jurisdictions have a land transfer tax or an affidavit of property value. If you pay the tax or provide the affidavit, then you're putting your property on the tax rolls. And if you think about it, that's perfect because you serve on them your instrument by registered mail to be recorded. And of course, they'll send it back to you saying it's not recorded, but it's in a special file. Well, that's perfect. That's the non-tax paying file. And if you, some counties require it to be a land title document before you can record it. It's easy to make any document a land title document by inserting in the top right-hand corner of the front page the following information. And so you just put up their land title document and then section, township, and range of where you're located or your land is located, and it's a land title document. Meridians are vertical lines on the earth that run from pole to pole. Ranges are horizontal lines that define the top and bottom of a township. A township is 6 miles square, 36 sections. A section is 1 mile square, 640 acres. An acre is 43,560 square feet. In older parts of the country, the meets and bounds legal descriptions run from landmarks like the old oak tree or where the rivers meet. And so you have to understand what a meets and bounds legal description is so you can understand what it is. A meets and bounds legal descriptions are common law. Every state has a base and meridian that all legal descriptions that are taken from. Alberta uses the 4th meridian, which is the eastern border of Alberta. Utah uses the Salt Lake Basin meridian. Arizona uses the Gila and Salt River meridian. Your local city planning department will probably be able to tell you what section your land is in and the basin meridian is taken from. An instrument is deemed filed in law at the time it is delivered to the clerk, regardless of whether the instrument is file marked. So that's why you serve it on them when you prepare your deed, and you don't send that affidavit of property value. If you think they're going to play games, serve it on them by registered mail. You have proof they got it, and they will not. They will just they'll leave it be. Okay, they'll tell you it's in our file, and that'll be the end of it. Okay, you got proof that you served it on them, and they perjured their oath. Is what you got proof of. But you know these people are Satanists. Anyways, we already did this one. The King of England held ownership of land under a different title and with far greater powers than any of his subjects. Though the people of England held fee simple titles to their land, the king actually owned all the land in England through his allodial title. And though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity with the king's title. See, you can actually have the king's title. Okay, that's where you go. That's the land, that's the title you can have. I know people who have land patents on the land and they pass it on their family and have done it for generations. They do not pay property taxes on it and it's never been contacted. I currently own land that's not on any tax rolls. A lot of it depends on how corrupt the local government officials are. Property taxes are theft and a denial of due process. I helped a friend bring forward a land patent on his property in Tarrant County, Texas, and then the friend died. The Tarrant County thieves continued to try and steal his property. His family did not have any idea about land patents and had no interest in defending it. The Tarrant County thieves sold his property with a tax sale. The friend's neighbor, okay, he happened to be the mayor of the town, the friend's neighbor bought the property at a tax sale. Another friend was talking to the neighbor about his purchase of the land. The neighbor said that because the land patent was brought forward, that he could not get bank financing. He had to get a friend to finance the mortgage. Okay, that's the power of the land patent. Okay, the banks won't touch it with a 10-foot pole. You won't get title insurance. Okay, that's perfect. That's what you want. You want it unassailable. If the banks won't touch it, nobody else will either. The reason you won't get title insurance is because there has to be an insurable value, an insurable interest. Okay. And the title insurance company knows that if you have a land patent, then the title insurance, that'd be fraud for them to sell you title insurance because you have something that's way better than the insurance. You have the land patent. They can't touch it. And so that would be fraud for them to sell it to you. What is due process of law may be ascertained by an examination of those settled usages and modes and proceedings existed in the common and statute law of England before the immigration of our ancestors. The expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. Okay, so that goes back to the Constitution. It is manifest it was not left to the legislative power to exact any process by which might be devised. The due process article is a restraint on the legislative as well as the executive and judicial powers of government and cannot be construed as to leave Congress free to make any due process of law by its mere will. And so bringing forward the land patent is always effective. Whether or not it'll be recognized by the local authorities depend on how corrupt they are. When you bring forward the land patent, you'll not be able to get bank financing or title insurance. You can do it with a transfer of the land. Okay, you can also do it with a confirmatory instrument. Templates of both are found in the files directory of the Yahoo group. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned, that the sword come and take any person from among them, he is taken in his iniquity, but his blood will I require at the watchman's hands. This is my effort to make sure that I'm blameless on Judgment Day, and either you're part of the problem or you're part of the solution. You're now watchman. I hope you're blameless on Judgment Day too. Circulate this video far and wide. Anyways, thanks for watching, and bring forward your land patents. Get absolute title to your land. I'm available to help, but I don't do it for free. But you can get everything you need off of the Yahoo group that you need for free. And so, but if you want me to help you, then I'm going to have to get something. Anyways, thanks for watching, and I hope you have a real nice day, and bring forward your land patents.